UK, there have hardly been any of these cases to date, and they're not class actions in the strict sense. What we're really talking about is big pieces of multi-party litigation against UK issuers of securities.
There are always going to be some risk of securities class action in the United States. That's a very robust market. However, I think going forward, what we tell clients are the risk of UK and securities class actions in other jurisdictions is starting to develop and be there. And the issue there is uncertainty. We're not quite sure how it's going to develop, but we do understand and do believe that you'll see more cases filed in other jurisdictions outside the US.
The question is whether we will see an enormous tidal wave of these claims, and I don't think anyone thinks that will happen. But certainly now that claimants and lawyers have got the hang of it, I think we will see more. The other contributing factor is the huge amount of litigation funding that's out there in the market right now. That just wasn't there 10 years ago. And
so between the sophisticated counsel developing the cases and the money available to potentially fund the cases, I think you've got a very attractive regime here for potentially bringing some of these class actions, the securities class actions, that now are no longer available to you in the United States.
Significant difference between the US and the UK is the degree of preparation and analysis that goes into it beforehand. Commonly you see in the US these actions begun very soon after the event in question, a matter of hours.
In the UK, the reverse is true. Claimant lawyers, I think in my experience, are actually very keen to ensure that they have put the claim as well as they possibly can, and that they're only pursuing meritorious claims, because unlike in the US, we have the risk of adverse costs exposure.
What I see coming from the US to the UK, I think, among other things, I would expect that the way that the litigants use expert evidence in the US, I think presents an opportunity for incorporating some of that into UK actions. So for instance, in the US, you bring in expert evidence at a very early stage to look at questions from causation to damages to the question of reliance, and you use that evidence to potentially challenge the case as a defendant or as a plaintiff to make your case and get your class certified. So I think expert evidence and how that's used in the US is something that we'll see kind of used more in UK proceedings.
The likelihood is that we will see more of these actions in the future. Undoubtedly, you've got claimant lawyers and third-party funders who have the know-how and resources to bring these claims. So yes, in my view, any meritorious claim is not going to be left on the table in the future. It's going to be pursued. But I don't think it's going to be the wave of class actions that some have perhaps predicted.